A Lubbock DWI arrest starts 2 clocks. Most people only know about one. You have exactly 15 days from your arrest to challenge your license suspension. Miss this deadline, and your license is automatically suspended on day 40, no appeal. But just requesting the hearing lets you legally drive for months past the 40-day mark. We'll show you how this second court case is the key to your entire DWI defense. First, understand this. The ALR hearing is not your criminal court date. It's a separate civil case with the Texas DPS about one thing: your license. Many people assume suspension is automatic after an arrest. This is false. You have the right to fight it, but you must act fast. An attorney makes certain the request is filed correctly and on time. Simple paperwork errors can cost you your right to a hearing. This isn't an informal chat. It's a formal legal proceeding with rules of evidence, sworn witnesses, and structured legal arguments. Here's the problem. In criminal court, the state needs proof beyond a reasonable doubt. In an ALR hearing, they only need a 50.1% likelihood. This lower standard makes it seem like the deck is stacked against you. So why is hiring a lawyer so effective? Because a skilled attorney views the ALR hearing as an offensive move. It's the first chance to get the officer's testimony, under oath, before the criminal trial. Your lawyer gets to lock the officer into their story months before the DWI trial. They can question every detail of the stop, the arrest, and the testing. This gives you a preview of the state's entire case. Any inconsistency or mistake uncovered can be used to attack the evidence in your DWI case. This testimony can lead to reduced charges or even a full dismissal of the criminal case down the road. So it's a powerful intelligence tool. But how does an attorney actually win the hearing itself? Let's look at the specific arguments they make. That 50.1% burden doesn't matter if the state makes procedural errors. A skilled attorney wins by finding flaws in the police report or paperwork. Did the officer have a valid legal reason to pull you over? If there was no reasonable suspicion, the entire case could collapse. Was the breathalyzer calibrated? Was the blood sample handled properly? Attorneys challenge the science behind the state's main evidence. The arresting officer is required to appear if subpoenaed. If they fail to show up without good cause, the case is often dismissed, a default win. So, how do you overcome the state's lower burden? By using legal expertise to hold them accountable for every single procedural step. Winning is the goal and it's achievable. But what if you don't? Is the effort wasted? Let's cover the consequences and your options. Losing the ALR hearing means a license suspension. This can range from 90 days for a first offense up to 2 years for a second refusal. Even with a suspension, you may not be without a car. An attorney can immediately petition the court for an occupational driver's license, or ODL. This lets you drive for work, school, and groceries. But getting one requires proving essential need, a process your lawyer handles. So an attorney helps you fight and helps get an ODL if you lose. But how does this circle back to help your main DWI case? Let's connect the dots. An ALR win is huge. You keep your license, and the DWI prosecutor knows their key witness has already been weakened under oath. But here's the most important takeaway. Even if you lose the ALR hearing, you still gain a strategic advantage. Why? The intelligence gathered. Your attorney now has a complete transcript of the officer's sworn testimony. They have a playbook for the criminal trial and know exactly where to attack. Fighting the ALR hearing is an investment in the best outcome for your more serious criminal DWI case. Ignoring it gives the state a major advantage. So let's bring it all together. After a DWI arrest in Lubbock, you're facing 2 distinct battles. One is the ALR hearing, a civil case with a 15-day deadline. With an attorney, it becomes an intelligence-gathering mission. The outcome of this first battle directly affects the second, more serious criminal case. A win weakens the state. A loss provides your defense blueprint. Going through this alone means you risk automatic suspension and handing a massive advantage to the prosecution. That 15-day clock is about your future. Do not wait. Do not let this deadline pass. You cannot afford to forfeit this critical first battle. Protect your license and your defense. Contact a skilled Lubbock ALR and DWI attorney today to schedule a consultation and take control of your case.